convene. Welcome back, everyone. Hope everyone had a happy Thanksgiving. I'm Paul Krikorian, Chair of the committee. I'm joined by Councilmember Mike Bonin, and Mr. Bonin, we're it today.
Okay.
So we're going to proceed expeditiously. I'd like to propose, unless you have any objections, items 7 through 10, all of which are Office of Finance refund claims as consent candidates.
Enthusiastic.
All right, and without objection, those will be deemed approved by chair and member. And then that's going to bring us to, by the way, I don't have any cards either for general public comment or on any specific items on the agenda. But if anybody is here who would like to offer public comment, please fill out one of the white comment cards in the back and bring it on up, and you will be heard. So that brings us then to items number 4 and 11, which I'd like to take together and invite up our representative from the City Attorney's Office.
For the record, sir, item number 4 is the City Attorney report relative to requests for additional positions of prosecutors and filing staff to meet increased cases resulting from the passage of Proposition 47, the Safe Neighborhoods and Schools Act. And item number 11 is motion, Kokori Weston Corretz, relative to staff resources for the City Attorney's Office to pursue QUATAM actions and other affirmative litigation in order to protect the city's interests.
Very good. Thank you very much. Welcome. Why don't we start with just a brief overview of the increased workload that's anticipated at the City Attorney's Office as a result of the passage of Prop 47 and what these positions will mean in terms of ensuring public safety, and then also separately with the more advanced litigation and QUATAM requests. I know that there was a recent we here recently approved the receipt of a multi-million-dollar judgment in favor of the city as a result of a QUATAM action. So perhaps you can give a overview about the opportunities that there may be for the city with these positions as well.
Okay, thank you very much, Council Member. To start off with the Prop 47 request, as we put in our report, we are anticipating receiving about 13,000 to 14,000 cases, new cases to be reviewed. Those are predominantly drug offenses, everything from possession, they're all possession of drugs, cases that we currently do not prosecute, cases that currently, prior to the passage of 47, were felonies and now will be misdemeanors. Our numbers are based on our work with the DA's office and LAPD using historical data, so we can't say that it's an exact science, but we are comfortable that we're in the ballpark as to the number of new cases we'll have to review. We anticipate out of those cases about 9,000 of them will actually be filed by our office, which is where the workload becomes more extensive on our part. Again, that's based on historical data. Another challenge that we have immediately out of the gate is that on February 1st, when the cases are transferred from the DA's office to our office, and they will come as a package, all pending cases will come at once, we're anticipating about 2,000 coming over on that date, which means we have to be as fully staffed as possible to receive those cases come February 1st. As a little side note that's not insignificant, we also anticipate 10,000 or more warrant cases, which the DA currently is handling. Those are cases of this nature, Prop 47 eligible cases, where there is an outstanding warrant on the defendant, and when that defendant is located, that case would come to us to process. And so there's 10,000 outstanding there, which can come in at, they will flow in on a steady basis, theoretically, over time. So the workload we're looking at is considerable. It's about a 17% increase of our current caseload. We've asked for 8 prosecutors and 7 support staff. It's very paper-intensive work, the filings, the prepping of the cases for the various litigation stages, prosecution stages. So that's why we've asked for so much support staff, so that they can be doing the work as opposed to the attorneys when appropriate. We believe that we have been probably low in our request. We understand from speaking to the DA's office that they staff these cases at a higher level than we've asked for. We did that, one, to be very frank, we weren't aware of the pending cases issue. That's something that came up over the last couple of weeks, so we didn't anticipate that. But we're also very sensitive to the budget issues of the city, and we are trying very hard to assimilate as much work into current staff. So our current staff caseloads will go up, even with these new positions, but we believe this is the bare minimum we need to try to get by and to process this work.
So I have to admit, the pending cases issue had not occurred to me either. So with the passage of Prop 47, any case that had not yet proceeded to sentencing would be downgraded if within the scope of that proposition would be downgraded to misdemeanor, even if it had already been tried as a felony and they were awaiting sentencing. Or
the pending cases issue arises from the cases that will be pending on February 1st in the DA's office as misdemeanors that they've handled from the date of November through February, the 3 months. They will have accumulated a caseload of misdemeanors that they're prosecuting during the transition period. That transition period ends on February 1st, so those misdemeanor cases, Prop 47 cases, will come to us as a bulk, as opposed to them all coming to us on November 5th or 6th.
Okay.
We negotiated a 3-month transition.
So they have not yet pled.
Okay, but cases that, so is it the point of when a plea is entered that dictates whether or not Prop 47
Yes.
applies?
If they've pled and are sentenced up to February 1st, the DAs have agreed to handle those cases.
Okay.
They anticipate that come February 1st, we'll have probably close to 2,000 of the pending cases formally handled by them will come to us.
Okay. And did you say that there's you're estimating about 13,000 cases that
13 to 14,000 on an annual basis.
On an annual basis. Now, within the scope of Prop 47 were wobblers that are now going to be misdemeanors as well, right? So some portion of those 13,000,
No, what we did was we took...
you already netted those out?
Yes.
Okay. So the cases that previously the district attorney reviewed first and then kicked to the city attorney's office, you're already excluding that from
Yes.
these numbers?
Yes.
That would be in our current caseload.
Okay. All right. So if these positions were not funded, if you didn't add the additional prosecutors, the choice before the office and the city would really be that these cases that previously would have been filed as felonies would not be filed at all.
Either these cases or other cases that we're currently prosecuting as misdemeanors, we would have to make some choices as to which ones we prosecute, or we'd have to pull resources out of some of our other programs that are equally as important, such as the neighborhood prosecutor program or some of our gang programs or things of that nature.
Well, I think if ever there was a case to be made for a mid-year budgetary augmentation, this is as important a public safety need, I think, that
Thank you, sir.
there could be in mid-year, in my view. Mr. Bonner, questions on this?
Yeah, thank you. I just want to I'm totally supportive of this. I just want to get sort of a more concrete sense of what the implications of the passage of Prop 47 are going to be like. Possession of crystal meth, is that something which the status of that charge switches as a result of 47?
Well, it becomes a straight misdemeanor.
Right, okay.
Although we have been prosecuting those types of cases, the ones we haven't had prior to Prop 47 were the straight felonies, which would be heroin, cocaine, peyote, oxycodone.
So someone's arrested for meth at Oceanfront Walk in Westminster, which, as MC knows, is probably not unheard of. Could you tell me how that is handled now, how that would be handled if we did not approve this, and how it will be handled if we do approve this, in terms of...
Well, it's difficult to say with methamphetamine because we handle probably 1,100 cases of meth right now. And typically, our hope with drug defendants is that as part of the sentence, we could get them into a treatment program, and if they successfully completed, then there would be a motion to dismiss. Our concern is primarily on the drug offenses that heretofore were straight felonies, where we have no experience in handling those cases. But again, the overall objective, particularly for the drug defendants, is to get them into some sort of treatment.
So let me ask the question less specifically then. Just take something that more generically was a felony, now will be classified as a misdemeanor. How is it handled now versus both scenarios if we approve or do not approve the funding?
Well, prior, when it was handled as a felony, more likely than not, that arrestee would be in custody. They'd have a right to a preliminary hearing. They'd be looking at a felony sentence, which is state prison. Under the misdemeanor scenario, if they've got proper ID, there's no likelihood that the offense is going to recur. They would be cited and released, and it would go through the misdemeanor process, which does not have a preliminary hearing associated with it.
And if we don't approve this, what happens? How do I justify we're spending a lot of money in the middle of the year? I understand the need. I just want to be able to articulate.
Well, I've been a prosecutor since 1979. We've never been in a situation where, as a prosecutor, we said we can't file these because we don't have the resources. And it puts us really in a terrible situation for public safety, because what cases do you not file?
Right.
Family violence, guns, gangs. And we have done our best with the support of City Council to look at alternative programs. Our ACE program, for example, to pull municipal code violations out. But in this type of scenario, we've reduced a whole variety of felonies that will now be handled as straight misdemeanors, which honestly I don't think we can just ignore.
Yeah.
A couple more specific questions. Proposition 47 allows for defendants who've already been convicted under one of these offenses to petition the court for resentencing under the misdemeanor
Correct.
provisions. Is that right? So would those petitions be handled by the original prosecutor or the new prosecuting officer?
Those would be handled by the DA's office.
The district attorney's office.
Correct.
Okay, so we won't incur any additional workload as to those past convictions.
Correct.
Okay, good. And this is obviously an issue that is going to affect every city in California. Do you have any sense of what other cities are doing and what their current caseload is or their anticipated
Actually,
changes in the case?
It only affects two cities, San Diego and Los Angeles. Every other prosecution agency handles both the felonies and misdemeanors, so they have the staff to do that.
Oh, I see.
Right.
I see. So, okay.
In other words,
So they just reallocate their staff internally
Sure.
to
change the complaint from felony to misdemeanor.
Okay. Any sense of what the current misdemeanor prosecutorial caseload in San Diego is for a prosecutor?
I don't know off the top of my head. I can find out, though.
It'd be interesting to know. Just my guess is that they're probably not as leanly staffed as we are. It's just a guess, but it would be interesting to know for comparative sake. And then finally, let's see. I don't know if the recommendation specified whether or not these would be resolution authority positions or not, but I think that would make sense given the fact that we're going into it's kind of a brave new world and we don't really know yet what this workload is. You may need a lot more. You may not need as much, we hope. But
Along those lines, Councilmember, one of the things that we would be doing and would certainly share with the council is tracking these cases, probably on a quarterly basis. Give us 4 months to get up and running
Great.
and see what it is, because our concern, quite honestly, is that we're going to end up in April maybe having to ask for additional staff. We're going to try to avoid that, but we need the numbers in order to really figure out what's going on or
Right.
what will go on.
So with that, I think we should move forward with the recommendations,
Absolutely.
Mr. Bond, and just with a clarification that those will be for resolution authorities, so that we can jigger it if we need to.
And how
Yes.
quickly will you be able to fill these positions?
We are ready to make offers as soon as we have the position authorities and the funding. We've talked to the CAO and agree with them that it should be 6-month, not 7-month funding, because realistically, January 1st would probably be when people could get on board, and that gives us a month to train, which is helpful.
Okay.
Yep, I fully support it.
That makes sense.
Yes, and Council, so with your, typically we do always go with resolution authorities for interim budget requests. Since they are resolution authorities, they would have to be reviewed again as part of the budget development for the next fiscal year. I think that was one of the asks that the department indicated in the recommendations. I know that they have submitted in their budget request for 15-16 these positions be continued,
Yes.
if I recollect. 6 months funding would bring the total to down to $437,582, and the source of funds at this point would have to be the reserve fund.
We would also specifically request that we be exempt from the managed hiring process to bring these people on board.
And I don't think you'll get any objection from either Mr. Bonin or I on that. We get lots of requests along those lines. In this case, I just don't see any way that you can possibly meet the workload by going through the normal
Right.
process without that kind of a waiver, and it's a direct impact on public safety. I think we must do that, so thank you for the reminder. And so with those changes, the recommendations will be approved by chair and a member, and we'll advance that to council.
Thank you.
Now, on number 11, the key town
On number
position.
11, the request, it directly comes out of the recent Keatam case, which you referenced, Mr. Purpurian, that we brought to your committee, I guess, over the last couple weeks, where we brought in, I think it was $8.7 million to the city, and that's general fund money. It's non-earmarked. What that indicated to us is that there is opportunity out there to do more what we call affirmative litigation. Keatam actions are actions that you may or may not be aware of that are brought usually by a whistleblower, and then the jurisdiction, such as the city, has the authority to intervene should it choose to. If we intervene and prosecute the case from that point forward, and there are cases where there are unfair business practices, for example, against the city. In the case that you just settled, it was a case where we were not, two of our contracts were not following the terms of that contract. A whistleblower became aware of that. It came to our attention through the Keatam process. We chose to intervene, and by doing so, we not only stop the practice, but we collect the settlement, and we get a greater proportion than if we were to contract it out on a contingency basis, or we were to let the whistleblower act on his or her own. So there's a definite benefit financially to the city to have the staff to pursue those cases on its own accord. The issue with Keatam actions is that they tend to be very complicated and sophisticated. They need a highly skilled attorney in order to do that, and so that is an area that we would like to pursue, and we believe we need an experienced litigator to bring those types of cases to the forefront. The other area that we think potential to explore and to pursue, but again need the litigation support, is in the affirmative litigation, the 17-200 unfair business practices. And those cases are brought on behalf of the people of the state, so they're currently out of our criminal branch, and they're brought against companies or businesses that have engaged in unfair practices against members of the public or the community. The real goal of that is to stop the practice, perhaps get restitution for the individuals that have been impacted, and often the damages or the corrective action is geared towards the individuals. It also has the potential of bringing in revenue to the city in fines and penalties that is statutorily the city is allowed to collect. So that's also a revenue-generating litigation, but again, with the 17-200, it really is aimed at stopping the practices and making whole the individuals that were impacted. Again, very complicated litigation, and one that we would love to staff, but we need the staff in order to do it.
Now, I've forgotten on 17200. It's been a while. There's private attorney general, private right of action under 17200, right?
There's
And
a specific statutory authority for the city to bring 17200 in the name
for the
of
city,
people.
but private attorney general can also do it as well, right? And I'm trying to remember if you can recover, whether a city can recover its attorney's fees. Is it just penalties, or can
Yeah, I
we get
don't know
reimbursed
the
for
answer. I'm not
fees?
the most fluent in
I
17200. I do know that in the cases that we bring under 17200, first of all, most of those cases settle, they don't go to trial, and as part of the settlement, we often collect the attorney fees
Yeah.
and costs.
Yeah, it's definitely an opportunity to, do a lot of good for the public, and I think recapture probably the full cost, if not more, of these positions, to be sure. Anything else on that? Okay. Members, any questions on this one? Mr. Blumenfield?
Just a comment. This is what the Keatam false claim stuff is something I've been very involved with for 20-plus years. I used to work for Howard Berman when he created the original Keatam law on the federal level, and then I actually was the person who expanded it on the state level, and part of the reason why we have more cases now is because of the expansion that included the federal stimulus, the UC system, and a bunch of other categories. So I'm very excited. I've seen, firsthand not only the money that can be recovered for public, but also how we can change practices is what you're saying, which is just as important. And so I'm very strongly, behind getting the positions. I spent a lot of time on this stuff, understand how complicated these cases can be, but it pays for itself in many different ways. So.
Definitely.
Thank you.
All right. I should have mentioned, sorry, that we have been joined by Councilmember Blumenfield. We have a quorum of the committee, so first let's go ahead and act on item number 11. I think I would propose that we adopt the recommendations, and if there's no objection, that will be the action of the committee. If we can go back to item number 4, since we have a quorum, and reconsider that item. Mr. Blumenfield, this was the addition of the Prop 47 positions. Did you have any questions about that? Okay. And there was no public comment on that item. Seeing none, public comment on that item is satisfied, and the recommendation was to approve the recommendations with an amendment to clarify that the positions were resolution authorities, and to provide 6 months rather than 7 months funding. And then there was a request for a managed hiring waiver, and Mr. Hale reminds me that we don't have within our authority the ability to waive managed hiring entirely, but this committee can instruct the CLA to advance those positions and encourage the other participants in the managed hiring process to do likewise. That's satisfactory.
That's a good way to go.
And for clarification, with the amendment to 6 months funding, is there an amendment to the timeframe for the resolution authorities? Right now, it states from December 1, 2014 through June 30th, 2015. Should that stay?
It can be January 1st through the end of the fiscal.
Yeah, well, it may as well be, since we don't have funding for it. So yeah, let's make those parallel. So with those amendments, if there's no objection, Mr. Blumenfield?
I don't have any objection. You may have covered this in your question, but I was curious about, is there any way we can recover some of the costs, since the DA's office, county office will probably have a reduction in some way that we could, probably not, but I thought I'd ask.
Only if you have very good connections over in the county. It would be obviously at their discretion. The proposition did not call for any switch and, transfer of funding, nor did it even contemplate, quite frankly, the impact on the city fiscally. Again, as Mary Claire said, most jurisdictions in the state don't have this issue because their DA handles both their misdemeanors and their felonies. So San Diego, LA are the exceptions, and it appears that nobody was thinking about that when the proposition was drafted.
Is there something we can do now if it's not written into the bill, but to try to either, in collaboration with the county or going back, for a state tweak to allow for, because it's the alignment issue, and it comes back from the governor's whole realignment, generally with prisons, but here's a different kind of realignment where the incentives and the actions aren't lined up, that it'd be good if there was a way for us to get some of that money.
I know that there have been discussions at the state level as to both the projected savings and what they should be used for. The proposition currently calls for them to be used for educational and rehabilitative services and access to those services. I know that there has been discussion about trying to get the city some additional money. I don't know exactly where that is and how successful it will be, but it's something that we are keeping an eye on.
Well, maybe we could add in as an amendment that we instruct our city lobbyists to, if it's already something like that in motion, to weigh in that we want them working on that issue. Would that be acceptable?
Can we do that consistent with these recommendations?
Yes.
I mean, it's
I believe
a
so.
little outside the scope of what's before us, but it's a perfectly good idea, and I think it's
I mean, it's something that you
relevant.
could definitely add to your legislative agenda, is request some
Yeah.
modifications at the state level for recouping some of these costs.
okay.
Absolutely.
Very good. Lost my train of thought.
One additional amendment to the recommendations that you already have.
Yeah. Oh, on offsetting savings or payment for some of these expenses, the Times raised an interesting point in its editorial that with the transfer of some of these cases to misdemeanor status, there may be less of a demand for police overtime for testimony during the felony process, that there will be less of a need for that. I'm not sure if that's going to be as big a difference as they seem to suggest, but it probably will be appropriate for us to get a report back from the LAPD as this process unfolds, so that we can actually see whether or not there have been such savings. It would certainly be welcome if we could reduce our overtime demand for officers' testimony, because that has been one of the driving forces for our excessive overtime, has been the need for officers to go and provide testimony and take a full day of overtime to go and testify. So if we can reduce that, that would be a significant savings to the department's budget, at least. So we'll revisit that. That doesn't need to be a part of this, but Matt, remind me, in a few months, we'll want to take another look at that. All right.
Thank you very much.
With that, thank you all very much.
Should we redo the consent calendar?
Yeah, so let's reconsider then items 7 through 10, which were my recommendations for consent items, Mr. Blumenfield, and I see no public comment on items 7 through 10, so if there's no objection, those are all Finance Department refunds. Those items 7 to 10 will be approved and advanced to council. Okay, so that brings us then to, we have 3 items for closed session. We also have our conflicts panel, items 5 and 6. I think I'm going to go ahead and take the conflicts panel items first, because we may have some questions on those that may require, well, can we go into closed session on those? It hasn't been agendized for that. Okay.
They have not.
All right, then let's go ahead and do our closed session items first so we can get our city attorneys back to the office. That would be items 1 through 3. Is there anyone here wishing to offer public comment on items 1 through 3? Seeing none, having no cards, public comment on those items is now closed. Is there anybody here who is not here on one of those items? Can you raise your hand? Just so I know whether we need to leave the room or not. Okay, we'll stay here. Okay, so we're going to go to closed session, and we'll be back in open session in just a minute. item on today's agenda or general public comment? Seeing none, public comment on all agenda items and general public comment is now closed. All right. And that brings us then to our remaining items 5 and 6.
Yes.
Which we can take together.
Items 5 and 6 are reports relative to the Attorneys Complex Panel. Item 5 is requesting authority to amend 11 legal services contracts with various law firms. And item 6 is to requesting to reassign 2 Attorneys Complex Panel cases.
Good afternoon.
Good afternoon. Dolores Rivera of the CAO's office. I have 2 reports concurrently together. One is seeking authority to amend 11 ACP contracts in the total funding amount of $1.382 million. They're consisting of various law firms for various assignment categories, 2 employment, the majority are police and litigation, that would be 7, 1 labor, and 1 appeal, but it is also a police litigation case. These cases also, in addition, they're a mixed bag. Some of them are partial conflicts, some of them are full conflicts. The Attorney Conflicts Panel itself has ceiling authority of $100,000 to fund contracts, and beyond that amount, we defer to counsel for authority to fund the contracts. The other request is to reassign 2 cases currently with an ACP-approved law firm, Haight Brown, and reassign these 2 cases to a law firm by the name of McKenna, Long, and Aldridge. The reason for that is because the lead attorney, an appellate specialist, handling 2 high-profile cases, has left Haight Brown to go to McKenna. So with that, we are seeking authority to reassign and to enter into 2 contract agreements with McKenna for total funding of $130,000 effective October 1.
Okay, so I wanted to hear these together in part because of those 2 matters, because the transfer of the case to follow the particular lawyer makes perfect sense to me, assuming it's pursuant to the same terms, the same
Yes.
billing
Same
rate.
rates.
Okay. Do we know whether McKenna has any potential conflicts that would, have we done that process yet to
The
check?
conflict, in discussing this with the research, it does not appear that there is a conflict.
Okay.
That would have come up already, and so I'm going to say no.
Okay. So if that's the case, and that goes smoothly as we would expect,
Right.
then do we still need to do the amendments to the...
Haight Brown
Yeah,
on this?
and the-
Yes, in fact, this report was actually pulled because of that, when this other came through, the news of the reassignment. So the 11 contract request was pulled to adjust the funding amount. So what we have, I think, down for Haight Brown is $25,000, and that would be to cover remaining invoices for closeout.
that are currently outstanding?
Yes.
Okay. Okay. Now, why do we have 2 different firms handling this appeal?
Oh, for the Chaudhry case?
Yeah.
Okay, that's a very good question. The reason is because Chaudhry, which I'll give a little bit of a background, that's a police-involved fatality of an autistic young man of
By the way,
Muslim...
keeping in mind, we're still in open session now. So don't...
Okay, and so the law firm of Ferguson Prate was the trial attorney handling the case.
Okay.
And so this case went to a jury trial, and then there was an appeal, and because of the complexity of the issues, the trial attorney deferred it over to an appellate specialist.
So the $75,000 for the Ferguson firm is for trial-related costs that are already invoiced?
Right. And now this appeal is at the final stages, so a determination was made by the Ninth Circuit, and so now that is being returned back to the trial level to finish out the case. So Ferguson Prate is actually stepping back into the picture.
Okay. All right. Now, for all of those items on this list for which the current contract amount is $100,000, these all make sense. You have a $100,000 limit for the initial request, right?
Right.
And then council action is required to increase it. But a few of these, the Collinson law firm in Boone, the Chaudhry cases, and the Garrett case, it looks like those are all matters that have previously come to the council for an adjustment above the 100,000 limit, because the current amount is already in excess of that.
Right. And a lot of these are cases that have wind down, that have already concluded, for example, the Garrett, the Boone. So it's just basically kind of taking care of closeout cases.
Yeah, and Boone and Chaudhry make sense, though I was going to ask you about Garrett, because even though this had come before council before for an increase above the 100,000, we're still coming back for another 165,000. And I guess I'm curious why we would have come back for a $40,000 increase above the original 100,000.
We underfunded
We
it.
came up 165,000 short. Was it just the case? What was the deal there?
With that one, that one actually came before council for settlement. We underfunded it, yes. And that's one of the dilemmas with when we get to that 100,000 threshold, whether to ask for the full amount or fund it incrementally as we do with our authority of 100,000. And so what I decided to do here was go ahead and ask for the full amount, but as I fund these contracts, I'm going to still do it incrementally, but just seek the full authority now.
And I appreciate that. I think what would be helpful, and maybe you need to do this in a confidential closed session kind of report, but to have the incremental funding is actually a good thing, because it allows council to kind of check in as the litigation is going, and that's a good thing. But it would be helpful also to know what the anticipated total budget may be, so that we have a context in which to assess that. So, and sometimes that's going to be hard, but you might say, if it goes all the way through trial, the estimated budget would be X.
Okay.
If we went on summary judgment, the estimate would be Y, those sorts of things. And then if we just do incremental increases, that's fine. I think that's a good thing, because it allows us, especially on the larger cases, to check in every now and then and exercise some oversight over our outside counsel.
Right, and it also slows down the money against the fund as well.
Yeah.
For the spending.
Okay. Mr. Bonin, any questions? All right. Then both of these items will be approved. Well, will be recommended for approval by chair and a member. And I think that's all the items before us. Our business is concluded, and we are adjourned.